the region's resources.
While we seek peace and dialogue, we must also be prepared to defend our interests, our people, and our environment.
So, once again, requesting all our guests to please settle down and proceed to their designated seats as we're about to start within the next 5 minutes. Once again, we're going to start within the next 5 minutes. Thank you very much.
We look back on as a defining turning point in our shared journey toward lasting harmony and prosperity. Mabuhay ang bagong Pilipinas.
Almost every day in the South China Sea, we are witnessing an alarming erosion of the rule of law. It's too complex a problem that there seems to be no solution in sight. Doing something could be seen as escalatory. Doing nothing could invite more aggression.
This dialogue is an opportunity to explore sound and pragmatic solutions that reaffirm and align our shared commitment to regional and global cooperation towards preserving and safeguarding the region's resources.
While we seek peace and dialogue, we must also be prepared to defend our interests, our people, and our environment. In this critical moment, we can craft a legacy rooted in collaboration and respect. One that future generations will look back on as a defining turning point in our shared journey toward lasting harmony and prosperity. Mabuhay ang bagong Pilipinas.
Almost every day in the South China Sea, we are witnessing an alarming erosion of the rule of law. It's too complex a problem that there seems to be no solution in sight. Doing something could be seen as escalatory. Doing nothing could invite more aggression.
This dialogue is an opportunity to explore sound and pragmatic solutions that reaffirm and align our shared commitment to regional and global cooperation towards preserving and safeguarding the region's resources.
While we seek peace and dialogue, we must also be prepared to defend our interests, our people, and our environment. In this critical moment, we can craft a legacy
Test.
rooted in collaboration and respect. One that future generations will look back on as a defining turning point in our shared journey toward lasting harmony and prosperity. Mabuhay ang bagong Pilipinas.
Almost every day in the South China Sea, we are witnessing an alarming erosion of the rule of law. It's too complex a problem that there seems to be no solution in sight. Doing something could be seen as escalatory. Doing nothing could invite more aggression.
This dialogue is an opportunity to explore sound and pragmatic solutions that reaffirm and align our shared commitment to regional and global cooperation towards preserving and safeguarding the region's resources.
While we seek peace and dialogue, we must also be prepared to defend our interests, our people, and our environment. In this critical moment, we can craft a legacy rooted in collaboration and respect. One that future generations will look back on as a defining turning point in our shared journey toward lasting harmony and prosperity. Mabuhay ang bagong Pilipinas.
Almost every day in the South China Sea, we are witnessing an alarming erosion of the rule of law. It's too complex a problem that there seems to be no solution in sight. Doing something could be seen as escalatory, doing nothing could invite more aggression.
This dialogue is an opportunity to explore sound and pragmatic solutions that reaffirm and align our shared commitment to regional and global cooperation towards preserving and safeguarding the region's resources.
While we seek peace and dialogue, we must also be prepared to defend our interests, our people, and our environment. In this critical moment, we can craft a legacy rooted in collaboration and respect. One that future generations will look back on as a defining turning point in our shared journey toward lasting harmony and prosperity. Mabuhay ang bagong Pilipinas.
Almost every day in the South China Sea, we are witnessing an alarming erosion of the rule of law. It's too complex a problem that there seems to be no solution in sight. Doing something could be seen as escalatory, doing nothing could invite more aggression.
This dialogue is an opportunity to explore
Once again, requesting all our guests to please be seated. We'll be starting in 3 minutes. Thank you very much.
to regional and global cooperation towards preserving and safeguarding the region's resources.
While we seek peace and dialogue, we must also be prepared to defend our interests, our people, and our environment. In this critical moment, we can craft a legacy rooted in collaboration and respect. One that future generations will look back on as a defining turning point in our shared journey toward lasting harmony and prosperity. Mabuhay ang bagong Pilipinas.
Almost every day in the South China Sea, we are witnessing an alarming erosion of the rule of law. It's too complex a problem that there seems to be no solution in sight. Doing something could be seen as escalatory, doing nothing could invite more aggression.
This dialogue is an opportunity to explore sound and pragmatic solutions that reaffirm and align our shared commitment to regional and global cooperation towards preserving and safeguarding the region's resources.
While we seek peace and dialogue, we must also be prepared to defend our interests, our people, and our environment. In this critical moment, we can craft a legacy rooted in collaboration and respect. One that future generations will look back on as a defining turning point in our shared journey toward lasting harmony and prosperity. Mabuhay ang bagong Pilipinas.
Almost every day in the South China Sea, we are witnessing an alarming erosion of the rule of law. It's too complex a problem that that there seems to be no solution in sight. Doing something could be seen as escalatory. Doing nothing could invite more aggression.
This dialogue is an opportunity to explore sound and pragmatic solutions that reaffirm and align our shared commitment to regional and global cooperation towards preserving and safeguarding the region's resources.
While we seek peace and dialogue, we must also be prepared to defend our interests, our people, and our environment. In this critical moment, we can craft a legacy rooted in collaboration and respect. One that future generations will look back on as a defining turning point in our shared journey toward lasting harmony and prosperity. Mabuhay ang bagong Pilipinas.
Almost every day in the South China Sea, we are witnessing an alarming erosion of the rule of law. It's too complex a problem that there seems to be no solution in sight. Doing something could be seen as escalatory. Doing nothing could invite more aggression.
This dialogue is an opportunity to explore sound and pragmatic solutions that reaffirm and align our shared commitment to regional and global cooperation towards preserving and safeguarding the region's resources.
While we seek peace and dialogue, we must also be prepared to defend our interests, our people, and our environment. In this critical moment, we can craft a legacy rooted in collaboration and respect. One that future generations will look back on as a defining turning point in our shared journey toward lasting harmony and prosperity. Mabuhay ang bagong Pilipinas.
Almost every day in the South China Sea, we are witnessing an alarming erosion of the rule of law. It's too complex a problem that there seems to be no solution in sight. Doing something could be seen as escalatory. Doing nothing could invite more aggression.
This dialogue is an opportunity to explore sound and pragmatic solutions that reaffirm and align our shared commitment to regional and global cooperation towards preserving and safeguarding the region's resources.
While we seek peace and dialogue, we must also be prepared to defend our interests, our people, and our environment. In this critical moment, we can craft a legacy rooted in collaboration and respect. One that future generations will look back on as a defining turning point in our shared journey toward lasting harmony and prosperity. Mabuhay ang bagong Pilipinas.
Almost every day in the South China Sea, we are witnessing an alarming erosion of the rule of law. It's too complex a problem that there seems to be no solution in sight. Doing something could be seen as escalatory. Doing nothing could invite more aggression.
This dialogue is an opportunity to explore sound and pragmatic solutions that reaffirm and align our shared commitment to regional and global cooperation towards preserving and safeguarding the region's resources.
While we seek peace and dialogue, we must also be prepared to defend our interests, our people, and
Once again, ladies and gentlemen, good afternoon. We will be starting within the next 30 seconds. So for those who are still standing, please proceed to your designated seats. Thank you very much. There you have it, ladies and gentlemen. We'll be proceeding with this afternoon's activity for the panel 2 of the Manila Dialogue on the South China Sea. We hope that everyone had a great lunch and a productive activity as well. Now, for our next panel, it will be for the Advancing the Rule of Law in the South China Sea, Perspectives from Claimant States. And to give the opening remarks, we respectfully request the Assistant Secretary, Maritime and Ocean Affairs Office, Department of Foreign Affairs, Philippines, Assistant Secretary Marshal Luis Alvarez. Let's give him a big round of applause.
Thank you very much. Distinguished panelists, Justice Carpio, Captain Liu, Dr. Permal, Dr. Vu, and our moderator, Attorney Ganchun, Excellencies, esteemed guests, colleagues, ladies and gentlemen. Good afternoon, magandang hapon po sa inyong lahat. It is an honor to be among you today and speak on this important topic of advancing the rule of law in the South China Sea. I do not need to repeat the reasons why the South China Sea is important. That is something you will hear from all speakers and panelists in this conference. What I am in a unique position to deliver is to articulate the perspective of the Department of Foreign Affairs, grounded on pronouncements by the President, in order to provide context as to the Philippines' perspective as a claimant state, and consequently, the importance of advancing the rule of law in the South China Sea. Allow me to recall that during the Shangri-La Dialogue last May, President Marcos delivered an insightful articulation of the 7 realities and 3 constants in today's international environment that provide a compelling framework for understanding the complexities we face and how the rule of law is imperative in the management of issues in the South China Sea. Among the 7 realities, he spoke of the reality that amidst the backdrop of a strategic competition between 2 superpowers, there are multiple actors in the region, which includes us, claimant states, with their own agency to uphold their aspirations. In this regard, I strongly restate that the Philippines rejects any attempt to downplay our legitimate interests as a true claimant state and rebuffs simplistic claims that our national interests only emerge from within the framework of great power competition. Another reality is the role of ASEAN. And in this regard, I restate the Philippines' firm belief that ASEAN must remain at the heart of efforts to manage the South China Sea disputes. These realities, among others, underscore the intricate interplay of variables shaping the world, including the South China Sea situation, and provide a context on which we anchor our foreign policy approach. And this foreign policy approach, in turn, keeps in mind 3 constants. First is sovereign equality. All states, regardless of size or power, are equal under international law. This principle is particularly relevant in the South China Sea, where we must resist attempts by larger states to impose their will or disregard the rights of smaller nations. Second is ASEAN centrality. ASEAN's central role in managing South China Sea disputes is indispensable. We advocate for ASEAN-led mechanisms, including the Code of Conduct negotiations, and call for a united and resolute ASEAN in upholding its leadership in the region. And third, and perhaps the most important, is the rule of law and multilateralism. We remain steadfast in our commitment to our rules-based international order, grounded in international law, particularly the 1982 UNCLOS and the 2016 Arbitral Award, both of which remain as the twin anchors of the Philippines' policy and action in the South China Sea. These 3 constants will continue to be a compass that will guide the Philippines' approach to addressing the challenges in the South China Sea. Among the ways the Philippines asserts its rights and interests in a fair and pacific way is to underscore the primacy of UNCLOS as the comprehensive legal framework within which all activities in the oceans and seas must be carried out, as well as to broaden acknowledgement of the Philippines' position reaffirmed by the 2016 Arbitral Award. The award is an affirmation of UNCLOS dispute resolution mechanisms and conclusively settled the issue of historic rights and maritime entitlements in the South China Sea. We have championed a consistent position. Maritime claims in the South China Sea cannot go beyond the substantive limits of maritime entitlements under UNCLOS. As such, no one country can claim almost the whole of the South China Sea as territory, and no country should mislead others with a narrative that is based on a wrong appreciation of UNCLOS. Advancing UNCLOS and the award also means consistently advocating the integration of the award's principles into regional and global ocean governance frameworks, and that it is a solid foundation for collaboration on many issues. We have always underscored, for example, the importance of the South China Sea as a global commons, given its importance in shipping, biodiversity, and environmental conservation and climate change, and practical applications of international law. During the Shangri-La Dialogue, the President reaffirmed our strategy of amplifying the importance of UNCLOS by stating that the Philippines will continue to build upon the country's significant footprint in enriching UNCLOS. As such, the Department of Foreign Affairs continues to expand its engagement with states based on common interests and advocacy for UNCLOS in all applicable venues. Recently, the International Tribunal on the Law of the Sea, or ITLOS, cited the Arbitral Award in key parts of its July 2024 advisory opinion as an authoritative basis for highlighting the duty of states to protect and preserve the marine environment. This citation makes it very clear that the award has become a part of the corpus of international law. In addition, the Philippines is moving to ratify UNCLOS's third implementing agreement, the Agreement on Biodiversity Beyond National Jurisdictions, or BBNJ agreement, because it is also important for us to be able to protect and tap into the rich biodiversity resources in the pockets of high seas that are found in the South China Sea. Our efforts to champion the primacy of UNCLOS has also compelled us to align our domestic law with it, and very soon we will have our own maritime zones law and archipelagic sea lanes law. These laws will provide further clarity as to where our sovereignty, sovereign rights, and jurisdiction apply, reaffirming what UNCLOS and the Arbitral Award have confirmed to be true for the Philippines. Our advocacy for the rule of law also means the Philippines remains committed to the process to conclude a substantive and effective ASEAN-China Code of Conduct in the South China Sea, which is currently under the co-chairmanship of Malaysia and China. While there are divergences in positions and alignments among the ASEAN member states, we continue to hope that ASEAN would demonstrate a unified and stronger stance on this issue. While the pace of the COC negotiations has to be improved, we remain confident that ASEAN continues to serve as an agent for peace and security in the region. The Philippines believes that the COC must be fully anchored on UNCLOS. While it is not aimed at resolving disputes, a COC has to effectively govern the behavior of parties at sea, while also ensuring that third country user states continue to enjoy the rights and freedoms in the South China Sea that are allowed them under UNCLOS. The President has consistently emphasized the urgency of concluding the Code of Conduct, and in his remarks during the recent ASEAN Summit, he underscored the importance of starting an earnest discussion on the milestone issues and the concept of self-restraint. The Philippines believes that improved coordination among the ASEAN claimant states is critical if we want to make substantive progress in this regard. And this is why the Philippines has initiated and will continue to convene an informal coordination meeting with other ASEAN claimant states as well as engaging with them bilaterally. Beyond regional and bilateral engagements, we recognize the importance of bolstering partnerships with like-minded nations that share our commitment to our rules-based order. We have deepened ties with countries that uphold international law, including through maritime dialogues, joint exercises, maritime cooperative activities, collaboration projects, and capacity-building initiatives. We continue to nurture maritime dialogues with particular countries to serve as a platform for discussion on various maritime-related issues, foremost being the advocacy of UNCLOS and the promotion of the arbitral award. These platforms, currently totaling 9, with a trilateral maritime dialogue coming up, have given us the opportunity to explore avenues for cooperation in the maritime space, as well as broaden consensus for UNCLOS and the arbitral award, and rally a common voice on various issues in international fora. At the end of the day, what's important is that words translate into actual action or change in behavior in the sea, in adherence with international law. The rule of law means that countries must refrain from illegal, coercive, aggressive, and deceptive actions to manage differences, and instead rely on peaceful means of dispute settlement under international law, especially UNCLOS. I recall paragraph 5 of the 2002 Declaration on the Conduct of Parties in the South China Sea, which calls on parties to exercise self-restraint in the conduct of activities and to handle differences in a constructive manner. It could not be more clear that the DOC calls for a constructive manner and not a dangerous or aggressive manner. For the Philippines, diplomacy and peaceful dialogue will continue to be anchors of our approach. Despite headwinds, we continue to engage with our neighbors to manage differences and prevent incidents from defining the entirety of our relationships. As such, we have consistently called for de-escalation and adherence to established mechanisms for dispute resolution prescribed and allowed by UNCLOS. We have, for example, made 2 submissions to our lawful claim to extended continental shelves with the UN Commission on the Limits of the Continental Shelf, or CLCS, and we are ready to explore a way forward with other legitimate claimant states. We are also not closing the door to legal proceedings under international law, including UNCLOS. These are all proper platforms to resolving disputes that do not resort to aggression. In all these undertakings, we emphasize the value of the rule of law as codified, especially in international treaties and agreements, not as weapons nor tools of aggression, but as platforms for recourse, which ensures that all states, regardless of their size or power, are bound by the same set of principles. No powerful state should be imposing its will by sheer might or pushing its domestic laws beyond its jurisdiction, disregarding settled maritime entitlements and the right of coastal states, of legitimate claimant states. This is the rule of law and not a rule by law. Ladies and gentlemen, the Philippines does not want conflict in the South China Sea. This much is certain. The decision to file a case for arbitration in 2013, which resulted in the 2016 arbitral award, is fully aligned with the dispute settlement mechanisms for international law, including the UN Charter. The award is a powerful example of the rule of law in action. At the same time, our commitment to the peaceful resolution of disputes is not only enshrined in the Philippine Constitution, but is also encapsulated in the 1982 Manila Declaration on the Peaceful Settlement of Disputes. As such, while we advocate strongly for the rule of law in the South China Sea, the Philippines will do so by continuing to pursue diplomacy and dialogue. Our diplomatic engagements are fully anchored on our desire to uphold peace, stability, and prosperity, not only in the South China Sea, but in the greater Indo-Pacific region as a whole. To end, allow me to paraphrase the President. The future of the South China Sea has already been envisioned by ASEAN, and all of us should fully strive to make the South China Sea a sea of peace, stability, and prosperity. Thank you. Maraming salamat po.
Thank you very much, sir. Once again, the Assistant Secretary for Maritime and Ocean Affairs Office of the Department of Foreign Affairs Philippines, Assistant Secretary Marshal Luis Alvarez. At this point, allow me to introduce our panel chair for the panel 2. Ladies and gentlemen, please help me welcome the Senior State Counsel, Department of Justice Philippines, Ma'am Freddy Ganchun. Let's give her a big round of applause.
Thank you for the introduction. I am a government official, but my only duty here this afternoon is to facilitate the dialogue on panel 2. So welcome everyone to panel 2, entitled Advancing the Rule of Law in the South China Sea, Perspectives from Claimant States. And for this panel, we have a description there that says that President Ferdinand Marcos Jr. of the Philippines, Prime Minister Phan Minh Chinh of Vietnam, Prime Minister Anwar Ibrahim of Malaysia, and President Xi Jinping of China have all articulated the importance of adherence to international law in managing and resolving maritime disputes. Why then are tensions in the South China Sea escalating? The panel will assess how major claimant states, the Philippines, Vietnam, Malaysia, and China, view the concept of a rules-based order vis-à-vis the South China Sea. Now, for this panel, we have 4 panelists, so let me introduce each of them. So first would be Senior Associate Justice Antonio Carpio. He is currently the chairman of the Institute of Maritime and Ocean Affairs Office of Manila. Please give him a round of applause to welcome him. Our next member of the panel is Captain Liu Xiaobo, a retired member of the People's Liberation Army Navy of China. Currently, he is the director of the Marine Studies Center Grandview Institution in Beijing. Please welcome and give a round of applause to our panelists from China. Then from Malaysia, we have Dr. Sumathi Permal. She is a senior research fellow from the Maritime Institute of Malaysia in Kuala Lumpur. Please give her also a round of applause. And our last panelist, surely not the least, is Dr. Hai Dang Vu of Vietnam. He's a researcher at the Diplomatic Academy of Vietnam in Hanoi. A round of applause for him also. So thank you, everyone. So this is how we're going to conduct this dialogue for advancing the rule of law in the South China Sea. Each of our panelists would give a 5 to 7 minute framing remarks or opening remarks. So we'll just follow this order. First, we'll listen to Justice Carpio, then to Captain Liu, then to Dr. Permal, and to Dr. Vu. Then after they have stated all of their framing or opening remarks, I'll be getting questions from the floor. So I would ask questions first, I will be asking questions by batch. So I'll ask questions first from this group in front of me, so 3 questions. And then I'll ask after the questions are answered, I will go to the next batch to my right. I'll get 3 questions from you guys. And then after your questions are answered, I'll get a group of 3 questions from this side to my left. And then another group of 3 from the participants here in front. And if there's still time, I'll go another round for the question and answer, all right? So without further ado, let us first listen to the opening or framing remarks of our distinguished panelists. Justice Carpio, the floor is yours.
Thank you. A pleasant afternoon to everyone. The South China Sea dispute, like any other maritime dispute in the world, is governed by 2 fundamental laws. The first is the UN Charter. The UN Charter says, these are the 2 basic principles of the UN Charter. 1, all disputes between states must be settled by peaceful means, by negotiation, mediation, and arbitration. So these are friendly means, peaceful means of settling disputes. Arbitration is a peaceful means of settling disputes. The second principle of the UN Charter is the use of force or the threat of force is prohibited in settling disputes between states. So these are the two foundational principles of the UN Charter. You remove these two principles, then there is no rule of law in world relations. The second fundamental law that governs the South China Sea dispute, like any other maritime dispute in the world, is UNCLOS, the UN Convention on the Law of the Sea. UNCLOS provides for a compulsory dispute settlement mechanism. When a state ratifies UNCLOS, it gives its consent in advance to be subject to compulsory arbitration in the future on the interpretation or application of UNCLOS. Subject to very narrow exceptions, they call this the opt-out clause, like if there are overlapping maritime zones. UNCLOS recognizes three basic maritime zones: territorial sea, exclusive economic zone, and extended continental shelf. If the overlap does not involve any of these maritime zones, then you cannot invoke the opt-out clause on overlapping maritime zones. Now, when China seized Scarborough Shoal in 2012, the Philippines did not send its Marines to retake Scarborough Shoal. We sent our lawyers to The Hague to invalidate China's 9-dash line. We followed the rule of law. We did not use force or threat of force. So that landmark award is, of course, binding on China and the Philippines, because when a state ratifies UNCLOS, it gives its consent in advance, and between China and the Philippines, there are no overlapping exclusive economic zones. And also, in the Spratlys areas, the tribunal said none of the geologic features in the Spratlys generate an exclusive economic zone to overlap with the exclusive economic zone of the Philippines in Palawan. So there could be no opt-out by China. So we followed the rule of law, and we're happy that the major naval powers of the world and like-minded states have supported us, have supported the rule of law in the South China Sea. So how do we advance further the rule of law in the South China Sea? There is an outstanding maritime dispute now among 4 countries on the overlapping extended continental shelf of the area in the Spratlys. You have Vietnam, Malaysia, and the Philippines claiming overlapping extended continental shelf claim. And you have China also, but China is claiming based on historic rights, because China's coastline is more than 350 nautical miles from this Spratlys area, and there are no overlapping exclusive economic zone or extended continental shelf. So we are back to the issue of historic rights. Of course, we all know that UNCLOS extinguished all historic rights in claiming maritime zones beyond the territorial sea, because that was the purpose. I mean, if historic rights could be claimed, countries will say, oh, 2,000 years ago, our fishermen went there to fish, and therefore we have a right to claim. So except for the territorial sea, all claims to historic rights beyond the territorial sea cannot be made anymore. So to wrap up, we have now the UN has approved the High Seas Treaty, the biodiversity beyond national jurisdiction, and it's now in the process of ratification. Of course, China has approved and will hopefully ratify the High Seas Treaty, but China has announced that there are no high seas in the South China Sea, and therefore the High Seas Treaty will not apply to the South China Sea, despite the ruling of the arbitral tribunal in its July 12, 2016 award that there are high seas in the South China Sea. So there is this looming problem because the states of the world will overwhelmingly ratify the High Seas Treaty, but China is saying the High Seas Treaty does not apply to the South China Sea because almost 90% of the South China Sea are within the 10-dash line of China. So that's another big problem. I end my remarks here. Thank you.
Thank you, Justice Carpio, for your remarks on the fundamental principles of peaceful settlement of disputes and the prohibition of the use of force, as well as the compulsory dispute settlement mechanism under UNCLOS and the key rulings in the arbitral award. Let me now proceed to our next panelist, Captain Liu. The floor is yours.
Thank you, Chair, and thank you for the Pacific Forum and to invite me here, and it's my pleasure. And I would like to share my personal view and assessment about Chinese policy on the South China Sea, and my presentation is on behalf of myself and cannot behalf of any official or behalf of my institute. And right now, I will not repeat any official statement because everybody knows Chinese officials and statement very clear, and I will not take any criticize or update to other countries' claims because, and from my personal view, I think every coastal state in the South China Sea have the equal position or equal standing to take their own claims. But right now, I like to focus on the clearing four common misunderstanding and about China's and South China Sea policy First, is China's claim and sovereignty over the entire South China Sea. I think is not correct because the Chinese claim are based on the sovereignty of the four archipelagic islands: Xisha, Zhongsha, Dongsha, Nansha, Paracel Island, Spratly Island, Paratas Island, and Scarborough Shoal. And based on this and the sovereignty of the island territory, and China claimed the territorial water and EEZs and continental shelf, and the historical right, and based on the 9-dash line. And so that's what I mean, and the China's claims in the South China Sea, not the whole South China Sea and sovereignty. The second misunderstanding is about 9-dash line. And as you know, the 9-dash line is nothing about the UNCLOS, because 9-dash line happened in 1947, and historically after World War II, and the Republic of China's government reoccupied the Spratly Island and Paracel Island. And in 1947, and the Republic of China's government and issued the map, the first map. The name is the maps of the location of the South China Sea islands, and with the dash line. And after 1949, the People's Republic of China inherited that. So in my personal view, the 9-dash line just mainly marks China's maximum claim of the rights, and including sovereignty right and other historical rights within that boundary, not absolutely sovereignty over the South China Sea, over the whole South China Sea. The third misunderstanding is that the South China Sea island doesn't mean the legal definition of islands and of the UNCLOS and the 1-to-1 articles. So, yes, the misunderstanding is that the South China Sea Island cannot be used to claim maritime and zones. But China's policy and that we claim the maritime interest based on the 4 archipelagic islands. That means that the legal status of single reef cannot represent the whole archipelagic islands and cannot affect the whole legal status of the archipelagic islands, these 4 archipelagic islands. And I will give you one example, the Taiping Island. Taiping Island, the Ituaba, and reoccupied by Chinese government, Republic of China, and in 1946, and is the biggest natural island in the Spratly Island. And after that, after 1946, and the Republic of China and still sent troops and occupied that. And after 2016, and the Chinese Taiwan leadership and Ma Ying-jeou have occupied his scholars and to visit that to show its legal status to fit the Article 121 of the UNCLOS. The last and fourth misunderstanding is that China has taken aggressive action towards its neighbor countries. But from Chinese government's viewpoint, and in 1988, the last armed conflict happened in the South China Sea. That is tragic. But after that, for almost 14 years, China has neither used armed forces or threatened to use it to resolve the dispute of these islands. And I personally think the Chinese government had fully executed the policy of South China Sea, the suspended dispute. And right now, if China's policy were too aggressive to dominate the South China Sea, I think China might have to control all of the island and reefs stationed by other countries, and almost 43 island reefs stationed by Vietnam, by Malaysia, by the Philippines, but there's no happen because China have refrained from its using force, even though China have that capability. And the second offshore, I don't think the second offshore is an island dispute because from Chinese government policy, second offshore is uninhabited island. There's only one tanker ship landing that. And from the DOC's regulation and the status quo of uninhabited island should maintain that. So that's a dispute. And in closing, I hope we can approach this discussion with clarified and focus on peacefully solution and should not just criticize each other's claim. And I don't think that's a very smart way to find the solution. Yeah, thank you. Thank you, sir.
Thank you, Captain Liu, on your remarks on the Forsha claim of China, as well as the 9-line, and that China does not claim sovereignty over the whole South China Sea, and that China has the capability to use force but has not used force. Let us proceed to our next panelist, Dr. Sumathi Permal. The floor is yours, Dr. Permal.
So, thank you, Madam Chair. Good afternoon, and thanks to the organizers of the Manila Dialogue for having me here at this important meeting. My role is to talk about advancing rule of law in the South China Sea. Bearing in mind, I'm not a legal expert, but I do understand the complexity for managing the South China Sea primarily lies on the use of rule of law and also the international law and UNCLOS and so on. So I will frame my initial remarks based on 3 points: the importance of rules of law, the regional strategic landscape that influences or add complexity in enforcing effective rules-based order in the South China Sea, and why, despite many efforts, for example, I spoke in 2012 in Manila about efforts to manage the South China Sea dispute, including capacity building, crisis management, having ASEAN as the centrality in managing China and ASEAN's negotiation in the South China Sea, appointing eminent person to deal with South China Sea and so on. And here we are in 2024, still, the situation, it's on the ground, it's not settled, but going towards, de-escalation and also even conflict. Why is it so? So the South China Sea involves two main issues, security issues. One is traditional in nature, and the second is non-traditional security. So it becomes a very unique domain where the state of affair is about the confluence of domestic and international law, as well as a theater for competing powers. So we have two different types of security issues, the traditional and non-traditional security, but the South China Sea issues involve not only the coastal states law, the national laws, but also the international law. So it has definitely become more complex than any other ordinary maritime security issues. So individual national interests, regional security and stability, and the confluence of international security for freedom of navigation, rule of law, and maritime governance are the main issues that makes the South China Sea issues, in particular advancing the rule of law, more challenging. So precisely because the international security has a large interest in the South China Sea, and this international security, regional security, and national security are different sets of issues. So it differs in terms of historical context, priorities for state. For example, for China, Chinese approach is usually about entirety in the South China Sea. For some claimants, their claims are only in the Paracel or the Pratas, and for Malaysia, for example, it's only focused in the Spratleys Islands. So the priorities and perspectives differs. So it is dealing with a set of shared challenges, and these challenges can be addressed, mitigated, or managed. As far as my observation concerns managing the South China Sea, of course we have managed to avoid a conflict, but it has become more volatile and more intense from the time that we were talking about as a de-escalating and managing it in a peaceful manner. So advancing rule of law is a foremost component in managing the international security in the South China Sea. So what is the main issue in advancing rule of law? So South China Sea is a collective action taken to prevent South China Sea security is a collective action taken to prevent or reduce conflict. So these actions may involve various methods such as military intervention, diplomatic action, international law and convention, regional agreements, treaties, and in the form of capacity building. However, there's disparity in legal perspective and accepting the rule of law. Primarily, the main diverging, contrasting perspective is the critical views of lawfare under the legal system. I would like to encourage everyone to read a piece of work by Yong Min Seo, 2024, from the Michigan Journal of International Law, where the article speaks very into detail about Chinese perspective of the closed sea concept and the US perspective of the open sea concept, and how UNCLOS is a careful balance of the interests of coastal and the maritime states. And here you would see the disparity that actually preventing many countries in the South China Sea to advance the rule of law in the South China Sea. One major issue is the gray zone tactics. Of course, there are many definitions. Gray zone tactics can be a tactic that is short of a confrontation, and a conflict relates to a non-use of military. It may be a cohesive action and a shy of armed conflicts, and it can happen during the peace and during an open conflict. So these are the situations that you can see in many pictures. Usually appears how some, especially the Chinese Coast Guard, have acted against some of the smaller vessels, including in the EEZ of Malaysia. So for Malaysia, Malaysia is chairing ASEAN in 2025. So as a chair, Malaysia commits to steering the association forward in strengthening regional peace and stability and prosperity. Two important elements in Malaysia's chair of ASEAN in 2025 is inclusivity and sustainability. So inclusivity, Malaysia will take inclusive perspective of all claimants, interested parties, especially the claimants in the South China Sea. And Malaysia has also a dual role as a role on an ASEAN-China dialogue relation coordinator from 2025 to 2026. So bearing in mind, there are three main approaches that Malaysia and also other regional ASEAN countries are approaching vis-à-vis the South China Sea. First is the diplomatic, legal, and institutional response. So it involves national laws. UNCLOS provides for a broad principle for ocean governance and framework. There are also other treaties such as DOC and COC. And one of the problems is all claimants are party to UNCLOS, but not all stakeholders are party to UNCLOS. So Malaysia and China and ASEAN states are working towards having a substantial COC. But I must emphasize Malaysia's position, or Malaysia, what we have seen in the media from the prime ministers and so on, that like many ASEAN countries, Malaysia do not recognize China's 9-dash line, also China's 2023 standard map, and Malaysia will not halt any oil and gas exploration in its EEZ. And Malaysia will continue to uphold its sovereign rights as provided under the international law. So advancing international law is highly linked to the strategic environment. So Malaysia practices neutrality in dealing with great powers, especially in the contested area. And Malaysia do recognize that balancing this delicate interest will remain a challenge, even though it's taking the chair in 2025. Thank you.
Thank you, Dr. Permal, for that comprehensive presentation on the issues in the South China Sea. You identified some of those issues, and then you also mentioned about lawfare and the closed sea concept, or mare clausum, versus the open sea concept of mare liberum. And you also mentioned about UNCLOS, which is a product of compromise that balance all of the interests of all states, the maritime powers and the coastal states. And you also mentioned about the gray zone tactics and the chairmanship of Malaysia. So thank you for that. Let us now proceed to our last panelist, the last but not the least, Dr. Haidang Vu. The floor is yours.
Can I have my PowerPoints on, please? Thank you. The person with the biggest heart in the Philippines, in my opinion, is Father Norberto Casella. He founded the Homeless People's Federation of the Philippines, which have helped build thousands of shelters for Filipinos across the country. So if we apply his big heart approach to the South China Sea, we can build a South China Sea shelter house, which doesn't appear here. Okay. Which should be open to everyone, claimants and non-claimants, Asians and Europeans. So how can we build such a South China Sea shelter house? So first, what kind of materials do we need to build a South China Sea shelter house? We will need a little bit of common sense, a little bit of flexibility, a little bit of inclusivity, and a lot of international law. We also need a good team of builders to build this South China Sea shelter house. And I would like to suggest that this team of builders will be headed by Justice Antonio Capio, one of the best lawyers in our region. I would like also to suggest that being part of this team, Professor Lan Anh Nguyễn Thị, who have just been nominated by the Vietnamese government to be a judge at the International Tribunal for the Law of the Sea. For your information, she is my boss. However, unfortunately, she's not here today, so too bad. I will not have a salary increase after that. Anyway, so now that we have everything ready, let's start building our South China Sea shelter house. It should build a private room for bilateral joint development between Vietnam and the Philippines, So earlier this year, both Vietnam and the Philippines have made our submissions of the extended continental shelf, and based on that, now we have an overlapping extended continental shelf where we can conduct joint development. And I think the most important principle to apply when you conduct bilateral joint development between Vietnam and Philippines is that what is mine, what is yours, also mine. If we can apply that, I think we're going to have a very successful joint development. Could also have a room for trilateral joint development between Vietnam, Philippines, and Malaysia, based on Malaysia's submissions of its extended continental shelf in 2019. So we have a huge trilateral zone between Vietnam, Malaysia, and Philippines where we can conduct joint development. We could also have a quadrilateral joint fishery cooperation between Vietnam, Philippines, Malaysia, and China, because the waters above our extended continental shelf is open for every country to do fishing. So Vietnam, Philippines, Malaysia, and China could create a... What happened? Hey, what happened, please? Yeah, so Vietnam, Philippines, Malaysia, and China could establish a joint fishery zone in this area. Sorry. I'm sorry, but I think okay. Yeah, so Vietnam, Philippines, Malaysia, and China could establish a joint fishery zone in this area where we can both join our efforts to do a sustainable fishery conduct. And since this area has the status of the high seas, so everyone should be welcome, because in the high sea, everyone has the right to come in. So in this case, everyone should be welcome if they are interested to do cooperation in this area of the South China Sea, so US, Japan, South Korea, India, Australia, and EU. And I would like to suggest that we will start first by doing a joint mine scientific research, which could help at the same time South China Sea state to understand better our high seas, and at the same time to contribute to the betterment of the knowledge of the world. So our South China Sea shelter house almost done. Just one issue left to be resolved, which is the Spratleys sovereignty dispute. Piece of cake. So in 2016, the arbitral tribunal has said no feature of the Spratleys could have more than 12 nautical mile maritime entitlement. So what we can do, it could freeze the sovereignty dispute, and then we could enclave on the islands of the Spratleys within 12 nautical mile radius, and we avoid doing joint development inside those 12 nautical mile radius because it might prejudice future resolution of the sovereignty dispute. So here, how it looked like our South China Sea shelter house, which is open to everyone, including homeless people. Finally, to conclude, I think that by applying the big heart approach, the big heart spirit of Father Babot, we could have a peaceful, prosperous, and sustainable South China Sea. Thank you.
Thank you, Dr. Vu, for that interesting presentation on the South China Sea shelter house, the materials for the construction of that house, and your proposed builders, as well as some of the cooperative activities, joint development, trilateral development, or quadrilateral fisheries in the high seas between the 4 claimant states, joint MSR, and with respect to the Spratleys dispute, which is a sovereignty dispute, you are proposing to freeze the sovereignty claims and to enclave the 12 nautical mile territorial sea of the high seas features of the Spratleys dispute. So you have all listened already to the opening or framing remarks of our panelists. So it's time for our question and answer. So if you have a question, you can just raise your nameplate like this. All right, and I'm going to call you. So I'm going to first ask questions from the participants in front of me. So this first batch, if you have any questions, you can raise your nameplate and I'm going to call you. I'm going to receive 3 questions first as a group, and then I'll ask the panel if they can answer any of those 3 questions that you pose to them. So anybody from our participants in the table in front of me? There. I was looking here. Thank you to my seatmate. First, I'm going to ask Madame Pabelina, all right? What is your question? And then after, so you state your question first, then I'll also ask your seatmate to state her question. Okay, the floor is yours.
Thank you so much. I'm Carla from the Philippines. I wanted to ask, and probably just for Captain Yu to further elaborate, in your perspective, what is the role of international law, including or particularly UNCLOS, in the peaceful settlement of disputes in the South China Sea?
All right, and then, so it's about UNCLOS dispute settlement and its role, the role of UNCLOS. And what about your seatmate? I could not see the name anymore. All right, can I get your question, please?
Yes, thank you, Madam Chair. And I'd like to have a question to Captain Xiaobo Liu. You mentioned that China has claims over the Foresha, and there's a confusion, in the discussions that whether the Foresha means that it's a single unit or it's a separated force islands group. Because as you see, the Foresha consists of 4 islands group in the distinct location. So can you clarify on that?
Okay, thank you for your question. So I'll ask Captain Liu first to explain further the Foresha claim of China, and then after that, I will ask other members of the panel if they want to answer the question of Ms. Pabelina on UNCLOS, the role of UNCLOS in dispute settlement. Captain Liu, yes. Thank you.
Yes, thank you. And from Chinese perspective, and China's sovereignty territorial of island just compares the Foresha Islands, and from my personal view, is 4 archipelagic island and comprise the Partas Island, Parsao Island, Spratly Island, and the Mystery Scarborough Shore. And all these islands, we claim the territorial sovereignty of island. So based on this island, and we can draw the territorial baseline and extend the 12 nautical miles, 200 nautical miles easy, and continental shelf. And that's the Chinese position.
Thank you, Captain Liu. Just to clarify, as Chair, I can ask a clarificatory question. You mentioned about baselines around the Foresha claim of China. Are these baselines straight baselines enclosing the maritime features, for example, constituting the Spratly Islands? Is it straight baselines, Captain Liu?
Until right now, and the Parsao Island have issued by the People's Republic of China as a territorial baseline, and in the 1996, and the Partas Island, Dongsha Qingdao, have issued draw the territorial baseline by the Chinese Taiwan administration. Right now, I think that's very clear, and China's then claim and about how to use the territorial baseline and to apply for these 4 archipelagic islands. But in the Scarborough Shore and the Spratly Island, that's definitely we have drawn the territorial baseline because and all this and the Spratly Island and many island and reefs and occupied by other countries. And I don't think is a good time to draw the territorial baseline before this dispute have settled. Yeah, is my personal view.
All right, thank you, Captain Liu. And with respect to UNCLOS dispute settlement, maybe Justice Carpio can start answering the question on...
Yeah, the question is, what is the role of UNCLOS in the peaceful settlement of the South China Sea dispute? UNCLOS is, of course, central to the peaceful settlement of the South China Sea dispute because UNCLOS is the constitution of the oceans and seas of our planet. All the disputant states, China, Vietnam, Malaysia, Brunei, Indonesia, the Philippines, are parties, have ratified UNCLOS. Indonesia is not involved in the territorial dispute, but its EEZ is also overlapped, encroached by China's 9, now 10-9. Now, UNCLOS is central because UNCLOS provides for a compulsory dispute settlement mechanism. When you ratify UNCLOS, you give your consent in advance to this compulsory dispute settlement mechanism. There are some situations where you can opt out, but in the main, you are bound by the compulsory dispute settlement mechanism unless you fall under the exceptions. And on questions of jurisdiction, the UNCLOS says any question on jurisdiction will be decided by the tribunal itself, and that decision is binding. If a party does not appear, just like what China did not appear, the UNCLOS says the tribunal will proceed to hear and decide the case on the merits. So UNCLOS provides for a compulsory dispute settlement mechanism. It's the first international treaty that has provided for a complete system of dispute settlement, because it provides for the law, it provides for the substance of the law, and then it provides for a compulsory dispute settlement mechanism. You are bound by that even if you do not appear. Thank you.
All right, would any other member of the panel add to that, or I can proceed now to the next question? Okay, I see none. So for the last question from this batch, because we have until 3:30 only, so it's 2:51 p.m. So
Sure.
for Mr. Dartman.
Thank you very much, Aristia from Indonesia. My questions goes to all the speakers. I think all of us agree that rule of law is very important, but of course there has been a lot of differences in interpretations and also gaps within a lot of ambiguity under international law. My question is that other than the code of conduct, of course we all consider the code of conduct is very important, but other than the code of conduct, what would you think the best venue for dealing or managing and ensuring rule of law in the South China Seas? I think Dr. Vu mentioning about the joint development agreement and so on, but what would be the framework, or it should be under the ASEAN mechanisms, or what are the other venues that is important as an alternative for the code of conduct? Thank you.
Thank you, Mr. Dartman. Maybe I'll ask Dr. Vu with respect to answer the question of Mr. Dartman. What is the alternative to the code of conduct?
Should I answer now?
Yes.
There's a very wise wisdom proverbs in the Philippines. It says, "Ang lakas ay daig ang para international law." So it means you can beat brute force by international law. I think that also answers the question of Ms. Pabelina. The importance of international law in this case is because if we go to war, you lose. If we counter the power with our small power, I don't think we stand a chance. So international law is our strength, it's our weapon of choice to go in this case. And it doesn't kill anyone. And if you look at the Charter of the United Nations, there are many ways that we can use to settle our dispute, from negotiations, mediation, conciliations, and of course, international tribunals, including both arbitration and international court of justice or international tribunal for the law of the sea. So there are multiple channels, multiple ways we can use to resolve our dispute, as long as we respect international law. Thank you, Dr. Damachian.
Dr. Vu, thank you for your question, Dr. Dharmawan. My eyesight's not very good anymore, so apologies for not stating your correct surname. But Dr. Vu, just to follow up, because I think I've read before that you wrote something on code of conduct for maritime engagements in the South China Sea. as an instrument that can be parallel to the code of conduct in the South China Sea?
I think the Indonesian had come up with also another type of code of conduct, not only focused on the South China Sea and not only focused on ASEAN and China. They want to have a code of conduct that open to all maritime domain of Southeast Asia and which should be open to all other states. I think it's a good idea as well, and we could have all those alternatives going in parallel. Whatever comes first, whatever can serve our purpose, to have a peaceful and prosperous South China Sea, we should use it. We also talk about queues, we also talk about maritime or air encounter code of conduct or other type of instruments. What's in the name? It doesn't matter the name. Whatever instrument which could have advanced the negotiation, which could have achieved a peaceful and prosperous South China Sea, we should use it. Thank you.
Okay, I think Justice Carpio would like to add something, and Dr. Permal, if you have something to say also.
The code of conduct, the purpose, the aim of the code of conduct is to manage the dispute so there will be no shooting war. The code of conduct is not designed to decide the merits of the dispute. The merits of the dispute will be decided by the arbitral tribunal or by the parties themselves if they want to negotiate. So we have to be clear, the code of conduct, the purpose of the code of conduct is to manage the dispute so there will be no shooting war, there will be a peaceful use of the seas, but the merits of the case will not be decided under the code of conduct. It will be decided by an arbitral tribunal or by negotiation of the parties.
Thank you, Justice Carpio. Dr. Permal, do you have anything to add?
I think the code of conduct is one of the peaceful management of the South China, peaceful way of management of the South China Sea. And during the early discussion of track 1.5 or track 2 on, there was substantial discussion on the geographical scope of the code. And I post 2016 decision of the tribunal, there's been many changes. And there's also, I believe that China and ASEAN countries are very positive to conclude a code, but I have no purview of the code, but I believe that it should include the most recent geographical scope of the code, which has to really consider the outcome of the tribunal's ruling. So then it will be an effective and substantial code. Thank you.
Okay, thank you, Dr. Permal. So I think I need to proceed to the next question. I see 9 who raised their nameplates, so we have 30 minutes only left. So just very quickly, somebody told me that you raised your nameplate actually ahead of Dr. Darmawan. Can I get your question, Ms. Lee? Just very quickly, what is your question, please?
Hi, thank you. So I'm Dana from Cambodia, a non-claimant state of South China Sea. So my first question is, this South China Sea conflict has prolonged for so many decades. What is the dynamic of the conflict that make it last for quite long and we see no solutions to that? Could I have a follow-up questions? Or if not, then I can have only this one questions.
Thank you.
Okay, thank you so much.
All right, maybe I'll get the 2 questions here first to see if they're related so that the panel can just choose to answer any of those questions. So the question from Cambodia is, what's the reason why this dispute is lasting so long? Why cannot it be resolved? All right, I'll go to Madam Parker, please. What is your question?
Thank you very much to the panelists. It was a really enlightening panel. I'm Jennifer Parker and I'm from Australia. I just want to explore this code of conduct discussion a little bit more. Of course, there is significant international law that covers the behaviour in the South China Sea and on the seas globally. And The collision regulations were mentioned earlier today, and I think they're not mentioned enough. Quite frankly, having been a mariner, I see that a lot of China, it is predominantly China, so I'm going to say that behaviour that doesn't comply with collision regulations. And although you mentioned, Captain Liu, that China has not applied a use of force, that behaviour has put at risk the lives of many people, including Australians, some of which are my friends and colleagues. So my question to the panel is, if the behaviours we're seeing in the South China Sea a clear fragrance of collision regulations, why would a code of conduct change any of these behaviours if international law is not currently being complied with? Thank you.
Thank you for that question. And the last question, Mr. Levy, please. Then I'll ask each of the panel to answer the 3 questions.
Well, thank you very much. My name's Peter Levy. I'm from the Australian Naval Institute. And I have a question for Captain Liu. You mentioned, I think, that the 9-dash line concept dates back to 1949. And I was wondering if you could expand on the rationale as to why China still uses that framework, noting Justice Carpio's point that the Law of the Sea Convention extinguished previous historical claims, particularly given the large area of water that the 9-dash line encompasses. Thank you.
Thank you for the question. So for the panelists, the 3 questions are as follows. First, why can't the dispute be resolved? Why is it lasting too long? And then with respect to the code of conduct, what we're seeing is that the collision regulations or the call regs are not being observed anyway, why would the code of conduct achieve any different? And with respect in particular to Captain Liu, there's a question from Mr. Levy on the 9-dash line, because as explained in the Ardbeer Award, historic rights were extinguished when a state becomes a party to UNCLOS. So I'll start first with Dr. Carpio. If you can answer any of those 3 questions, and then Captain Liu, and then Dr. Permal, and then Dr. Vu. All right, Justice Carpio, please.
On why the dispute has persisted, the dispute in the South China Sea. Well, there are several countries, nuclear-armed states, that lost in the arbitration. The U.S. lost to Nicaragua in the arbitration involving the mining of the territorial sea of Nicaragua. The U.S. said, we will not comply, but eventually the U.S. complied to the satisfaction of Nicaragua. The U.S. said, we will not pay you damages, but we will give you economic aid. And that was acceptable to Nicaragua. So Nicaragua withdrew its case before the ICJ because it was at the damage. They were now deciding the amount of the damage. So the U.S. finally complied. No? Then UK lost in the arbitration over Mauritius. UK said, we will comply. India lost in the arbitration over the Bay of Bengal with Bangladesh. India, nuclear-armed state, said, we will comply. Russia lost in the Arctic Sunrise case. Russia said, we will not comply, we don't recognize the tribunal. Eventually, Russia agreed to pay damages, although the Netherlands agreed to a lower amount. So 4 nuclear-armed states lost in the arbitration, and they all complied eventually. China is the only state that has not complied with an arbitral award when there is a compulsory jurisdiction. But I'm hoping that maybe 5-10 years from now, China will comply. On the question on the 9-dash line, 9-dash line was only was invented by the Kuomintang in 1947. It was adopted by the Kuomintang. But in the arbitration, it is a historic right claim. The Kuomintang said the South China Sea within the 10-dash line belonged to China since 2,000 years ago. But in the arbitration of The Hague, Taiwan under the nationalists, under President Ma at that time, intervened through the Taiwan International Society. And the Taiwanese intervention never mentioned historic rights. The Taiwanese argued exclusively on UNCLOS to prove that Ito Aba generates an exclusive economic zone. So the nationalists who invented the 9-dash line in 1947 went to the tribunal but never argued on the basis of the 9-dash line. They argued solely based on UNCLOS. So you have now the inventor of the 9-dash line not claiming anymore historic rights, the Kuomintang, and the Communist Party expanding the 9-dash line claim to include everything. It's not only a claim to islands, but a claim to the entire waters and islands within the 9, now 10-dash line. Thank you.
Thank you, Justice Carpio. So I'm now going to Captain Liu. Captain Liu, there are two questions that are specifically directed to you. First, with respect to collision regulations, the violations of China of the collision regulations, because people are seeing ramming incidents in the South China Sea, as well as the 9-dash line, the basis of the 9-dash line. And then the question from Cambodia, why does the dispute persist? Thank you, Captain Liu.
Yeah. First, then I would like to clarify that the misunderstanding about the 9-dash line. So, as the judge have said, I don't think so. The 9-dash line have raised the Chinese sovereignty about the historical right only come from the Kuomintang. No, the people's, the Republic of China issued the published the 9-dash line in 1947, and until right now, the Chinese and Taiwan administration still insist on the 9-dash line. And if you trace in the 2022, the Chinese Taiwan's the administration's the maritime the white paper, maritime 海洋政策 maritime policy white paper, and I quoted in the Chinese and the U-ship line, the Chinese Taiwan administration used that U-ship line to include the 9-dash line to the all the island reefs and of the Spratly Islands, which inside the U-ship line is belong to the Republic of China. So from the China-Taiwan's policy, because the 9-dash line come from the ROC, and the 9-dash line is the maximum claim of the territorial sovereignty of the island. And from the People's Republic of China and inherited by the ROC, and also claimed all the island and reefs and reach inside the 9-dash line. And have you said then why the China didn't until right now and insist to use 9-dash line to counter UNCLOS? And I don't think the 9-dash line have nothing has relation with UNCLOS, because the 9-dash line is only related of the sovereignty territory of the islands. The dispute of the sovereignty island then cannot judge or cannot regulate by the UNCLOS. UNCLOS have nothing with the islands, their territory. So that's very easy. Yeah, thank you.
Captain Liu, what about the violations of the collision regulations?
Oh, sorry, I forgot your first name, but from my, I would like to share the Chinese view on how to and to solve the maritime dispute in the South China Sea just in accordance with UNCLOS. Because I give first one example. Just China have make a delimitation with Vietnam in the Babel Gulf, in the Tonkin Gulf, and please noted the Tonkin Gulf the delimitation not only but in accordance with UNCLOS and not only related by the maritime delimitation, territorial sea and the EEZ, and but also there's the island dispute and inside the Tonkin Gulf, inside the Babel Gulf. There's a Bailong Way Island in the middle of the Tonkin Gulf. So by the delimitation, China make a maritime delimitation with Vietnam successfully in accordance with UNCLOS. So that's the Chinese policy and Chinese practice.
Sorry, I'd just like to clarify my question, because actually my question was about collision regulations, and as speaking to a former naval officer, of course, you're familiar with collision regulations, how ships should maneuver with each other. So my question was, given that we have seen Chinese vessels, Chinese naval vessels breach collision regulations and aircraft endangering Australian lives and others, why would the code of conduct be complied with if the Chinese Navy is clearly not complying with collision regulations? Just to clarify my question.
Oh yes, I don't think the Chinese Navy warship have involved some the incident happened in the South China Sea right now or before that. And until right now, all the Chinese operation or activity in South China Sea is about the law enforcement operation and conducted by the Chinese Coast Guard. Chinese Coast Guard is not a Chinese warship and a Chinese Navy vessel. Until right now, we didn't see any Chinese warship have involved any incident. And yeah, that's true.
Thank you, Captain Liu. Dr. Permal, would you like to add anything, answer any of those three questions?
Yeah, maybe on the question by the Cambodian colleague on why the dispute is so long and it is difficult to settle. I think three main points. The South China Sea it holds strategic interest for China. China's white paper covers the strategic interest and strategic reach of the South China Sea and becoming a dominant maritime power. The US has a huge interest in exercising freedom of navigation in the South China Sea, and also there is multiple military developments in the South China Sea. So you have a confluence of strategic and military development, plus the smaller claimant states like Malaysia, Vietnam, and Philippines struggling to, we are a party to UNCLOS, and we are trying to enforce our sovereign rights in the South China Sea by conducting joint oil exploitation and exploration, and we face some harassment, and also this makes the South China Sea dispute more challenging than any other dispute in the maritime domain. Thank you.
Thank you, Dr. Permal. Dr. Vu, would you like to answer any of those questions?
Thank you, Madam Chair. I would like to answer to Ms. Danielle Lee question, why the South China Sea dispute lasts so complicated and lasts so long? Please blame me to the lawyers. If the South China Sea dispute could be resolved, then we're going to be jobless. What else could you do? Divorced? No, actually, in fact, territorial dispute and maritime disputes are very complicated. Not only in the South China Sea, all around the world, there are about 400 maritime disputes which have been linger there for a very long time, which have not been resolved. Let me give you an example. The Asian Sea dispute, very complicated as well, and it has not been resolved. Or the Falkland Malvinas Island between the UK and Argentina is also a very complicated dispute, and it has been there as long as the South China Sea dispute. So territorial disputes are complicated, but we still have hope. Like, for example, recently the UK just promised to give back the Chagos Islands to Mauritius. That's a very good example. Or about a few years ago, India accepted to go to court with Bangladesh in order to resolve their maritime dispute. So there are hope that sometime countries would come to their sense and try to resolve definitively their maritime or territorial dispute. Let's hope the same thing for the South China Sea. Thank you.
Thank you, Dr. Vu. So I'll now take three more questions. So first, Dr. De Castro, one question, please. What's your question?
My question is directed to Dr. Bu and to Dr. Sarmal. It has something to do with the code of conduct. Of course, having a code of conduct agreed upon by ASEAN is also challenging within ASEAN, because we have to accept the fact that the continental Southeast Asian countries couldn't care less about the South China Sea and, of course, the code of conduct. So I still remember this in 2015, the Philippines had this proposal for at least for the 4 claimant states, Brunei, Vietnam, Malaysia, and the Philippines, to at least have a code of conduct on their own. And of course, this was repeated again by the current administration. Unfortunately, that very modest proposal of just a code of conduct for the 4 claimant states have not taken off the ground. How is this viewed by Vietnam and of course Malaysia? Are these other 2 claimant states amenable for a code of conduct just among the 4 claimant states?
Thank you, Dr. De Castro. So I'll take 2 more questions. So Dr. Vu and Permal will answer that in a bit. I'll take the question of Mr. Arsana and Patalano, please. Arsana, yeah, do you have a question, sir? Yes.
All right, thank you very much. I really appreciate the presentation from the speakers. I paid attention in particular to Dr. Vu's presentation with the maps. I really like the way you presented, so it's easier for me to understand the spatial context in it. I paid attention particularly to the way you, if I may say in my term, localize the issue by giving, for example, the small rocks and islands only 12 nautical miles based on the recent 2016 decision. I like that approach. Now I want to make it broader now. How should we utilize the same decision to treat our own islands, for example? I remember Indonesia has a lot of small islands, Vietnam's also, Malaysia, we have Dr. Permal here. How should we apply those decisions or principles in terms of us treating our own islands, let's say how to use them as a baseline or base points, how to use them as a reference for maritime zones, for example, and also in terms of maritime delimitation. If you have that opinion on that, I'll be happy to hear. Thank you.
Thank you, Mr. Arsana. So that's a question directed to Dr. Vu, just to take note. And then Mr. Patalano, please, your question.
Thank you, Madam Chairman. So a very quick question. I want to go back to the title of this panel, Advancing the Rule of Law in the South China Sea. So it's clear that the code of conduct, if he were to come alive, would not be about solving disputes, but managing disputes. So the question for all the panelists, in what practical ways you expect a code of conduct to actually advance the rule of law if it is about managing the disputes rather than solving them? Thank you.
Thank you, Mr. Patalano. So that's related to the code of conduct and how it can actually advance the rule of law. So I'm now going to ask first Dr. Vu, because 2 questions are directed to you, and then you can also answer the last question on how can the practical ways of advancing the rule of law.
Thank you, Madam Chair. I would like to answer the question of Professor De Castro first. If I remember well, between Vietnam and the Philippines, we also signed a bilateral code of conduct during the 90s. So I think we are not against that code of conduct approach, but you have to look at it from a practical point of view. Like sometimes between close friends, between brothers, you don't have to sign anything. We just do it, you know. Of course, we can negotiate a code of conduct for fun, but what purpose it will serve if you negotiate it, you sign it, and we don't respect it? Whereas between friends, sometimes you don't even have to sign anything. We just do it. We just cooperate, like what we did with Malaysia. We have a joint development with Malaysia in the Gulf of Thailand, where I believe in the past we leave to the Petronas to do all the field work. We just help them. So if we can achieve that level of trust, we don't need any additional code of conduct. For Mr. Asana, even before the arbitral tribunal, Vietnam have applied international law, especially the law of this UNCLOS, with regards to the effects of islands during our negotiations of our maritime boundaries with our neighbors. Like for example, when we negotiate the maritime boundary with China in the Gulf of Tonkin, some of our islands, we don't claim to the full 200 nautical miles, but we have only partial effect. We did the same thing with Indonesia with Thailand, when we negotiate about maritime boundary with Thailand in the Gulf of Thailand, where some of our islands in the southern part of Vietnam only given a partial effect. So Vietnam have been applying the international law relating to maritime entitlement of islands even before the arbitral tribunal. And now that these have been confirmed by the arbitral tribunal, we will continue to apply these regulations, these law relating to islands, even more actively. Thank you.
Thank you, Dr. Vu. So to Dr. Permal, the question of Dr. De Castro is, what happened to this proposal to have a code of conduct, like a mini code of conduct among the 4 claimant states only?
Yeah, thank you very much, Professor Castro. I agree with my colleague, Dr. Wu. Yes, there was a proposal, and before a code of conduct between the 4 claimant states, there were also proposals on joint fisheries management issues between Vietnam, Malaysia, and Indonesia, for example, but it did not materialize. As you rightly pointed out, that even among the claimant countries, there are issues that we have not agreed upon and we have not resolved, especially on fisheries issues, for example. So that is one. So I think rather than embarking on a new code, what is more important is try to, as much as we can, conclude a COC that has already been negotiated, has already been discussed and agreed at the institutional level, and also being discussed with all the dialogue partners. That would be more politically and also success in the management between China and ASEAN. And this brings my second point to the question of Dr. Patalano, that whether the COC is a final solution or a complete solution to advancing rule of law. No, it is not, because a COC is a political document, and a COC is part of the discussion between ASEAN and China to de-escalate or to diffuse the extensive militarization in the South China Sea 10 years ago maybe, but it has not materialized. Besides the COC is not the final solution, as I mentioned. This is my opinion. Countries can enforce or advance rule of law by having their, it is given because like Malaysia's position or Malaysia's official position is abide by international law, including UNCLOS. So UNCLOS provide for some jurisdictional for coastal state to enforce its law, Coast Guard's law, and also, enforce its sovereign rights. So this is what I'm proposing, and I'm pushing that countries should also focus. Thank you.
Thank you, Dr. Permal. Okay, I think I'll proceed to 3 more questions because I'm conscious of the time, but any of the panelists can answer any of the previous questions. I'll take the questions from Mr. Takagi and 2 others on that side. Yes. Please introduce yourself here.
Thank you very much. My name is Takagi. I'm from National Graduate Institute of Policy Studies, and I have 2 questions. And yesterday and today we talk about South China Sea issue, and then some of the speakers mentioned ASEAN role, and the document that came to my mind is that ASEAN outlook on the Indo-Pacific. And the first point of the area of cooperation on this document, the AOIP, was a maritime cooperation. And in that document, the policymakers mentioned about the role of UNCLOS. So how do you see the kind of the document after the launch of in 2019? It's already past 5 years, and then almost nobody talk about it. So in my observation about AOIP fair, like AOIP is gone, or is there any way to revive AOIP, especially for next year ASEAN chair Malaysia, for instance? That's first point. And second point is a bit different, but I want to make a kind of bridge between the panel 1 and panel 2 today. This morning we talk about role of law enforcement agencies in South China Sea issue. And we learned that we have some kind of different perspective about the role of law enforcement agencies and the meaning of rule of law in each country. So I'm curious about kind of agenda you may set up for next year ASEAN, meetings to talk about like a common understanding between distinction between like law enforcement and then the military activities in South China Sea. That's the second point. Thank you very much.
Thank you, Mr. Takagi. I didn't get the first question. You're talking about the 2019 instrument?
Yeah, I'm talking about ASEAN Outlook on the Indo-Pacific. That's a document.
Outlook, ASEAN Outlook on the Indo-Pacific. All right. And then the next question, please. Yeah, please introduce yourself, Madam.
Thank you, Madam Chair. Atsuko Kahara from Tokyo, Japan, the past president of the Japanese Society of International Law. I would like to make a very brief comment on the term claims, as the words claimant states are included in the panel 2's title. As I told you in the previous session, claims should be based upon law for the rule of law. In addition, strictly speaking, claims should be accompanied by convincing facts and convincing arguments. Otherwise, they would be just unfounded, groundless commitments. This point is very important for prevention of unnecessary tense situation, unnecessary dispute. Thank you.
Thank you for that question. Next question, please. And I'm going to get the question also of one participant here to my left. So we have 4 questions for the panelists. Yes.
Thank you very much, Madam. I'm Captain Kendall Furuya of Japan Coast Guard. I'm teaching at the National Graduate Institute for Policy Studies. Well, my question is what would be the effective or legal countermeasures against gray zone tactics? As Dr. Palmer correctly pointed out, we observed that the lawfares or gray zone tactics in South China Sea, if we look into those gray zone tactics very carefully, some are legal under international law, or for example, the just presence operation in the EEZ, that is under the freedom of navigation and that is legal. So my question is, how do you, or what would be the best countermeasures against those legal but uncomfortable gray zone tactics for the coastal state? And the second question is specifically to Captain Liu. I understand that you are ex-Navy and not Coast Guard, but what is your perception of the Chinese Coast Guard cutters ramming into Philippine Coast Guard, or use of water cannons, a long-range acoustic device or laser that can be said or that can be categorized as non-lethal weapons against Philippine Coast Guard? Would it be a use of force, or wouldn't it be a violation of international law, particularly the immunity of the Philippine Coast Guard? That's my question. Thank you very much.
Okay, your questions are duly noted. And the last one, I think, is it Mr. Do? What is your question, please, sir? And that would end the taking of questions.
Thank you, Madam Chair. So my question would address to Captain Liu Xiaobo, because you also raised one of the example that Vietnam and China negotiated the delimitation in the Gulf of Tonkin. And I think that is one of the success. And the success because of 2 reasons that Vietnam make 2 very important compromise. The first one, before that Vietnam also have some claims based on the history, especially based on the Franco-Chinese agreement, 1885. And Vietnam then later give up that claims, and we fully apply UNCLOS to negotiate the limitation. The second, mentioned by Dr. Vu, that Vietnam also claimed the full set of maritime zone for Bạch Long Vĩ Islands, and later we also agree that we limit the effect of the island there. So if you mention that Vietnam, that case is successfully and how the South China Sea bridge so what, so do you agree that China should also agree on strict application of UNCLOS for the negotiation on that? And the second one with the 9-dash line. So once again, I thank you for the clarification. So is that correct? If I'm wrong, is that the Chinese government now give up the 9-dash line claims only based on what we call the four-share claims? So is that right? Thank you.
Okay, so that would, I think, conclude the getting of questions because it's 3:30 exactly. So I'm going to let each of the panelists speak and they can answer any of those questions, but take note that there is a specific question directed to Captain Liu with respect to ramming, use of water cannons and lasers. What is your position on this? And with respect to the question of the negotiations, the agreement on the Gulf of Tonkin, as well as the maritime zones provided in UNCLOS, vis-à-vis, of course, the validity of the 9-9 and the four-share claim. There's also a question on the 2019 ASEAN instrument, outlook on the Indo-Pacific. There's also a question on the role of law enforcement agencies in the South China Sea. There's also a question on countermeasures to be taken against gray zone tactics in the South China Sea. And lastly, there's a comment on the word claimant states, because the title of this panel is Advancing the Rule of Law in the South China Sea, Perspectives from the Claimant States. And there is a comment that you can only be considered a claimant state if your claim is actually anchored validly on UNCLOS and international law. So you have all of those questions, 5 questions in all. So I'm going to ask each of the panelists to answer any of those questions, and then we conclude this panel. Thank you. So first, Justice Carpio.
Let me go back to the Code of Conduct. The Code of Conduct was conceived in 2002 in the Declaration of Conduct of the Parties. That's 22 years ago. At that time, China said, we will sign the Code of Conduct at the appropriate time, when the time is ripe. Well, 22 years have passed, the time is not yet ripe. And there are problem areas. Vietnam wants to include the paracels in the Code of Conduct, in the scope of the Code of Conduct. China wants only the Spratlys. The Philippines wants the Scarborough Shoal to be included, and also the Arbitral Award to be included. So I really do not see any progress in the Code of Conduct. On the question on the use of water cannon, the UN Charter says you cannot use armed force to settle a dispute. Is the use of water cannon an armed attack or an armed force? Aside from that, there's also the question of proportionality. If you are subject to armed attack, your retaliation or your response must be proportionate to the nature, scope, and gravity. So if the other side uses a water cannon, you should also use a water cannon. You cannot use missiles. That's why you see these vessels, Coast Guard ships of China and Japan, where they use water cannons only. So it's not a question of if they use, let's say, they fire a weapon, your response must be proportionate also. You cannot use atomic bombs or nuclear weapons. So it's not only the nature of the weapon use, but the proportionality of the response. Thank you.
Thank you, Justice Carpio. Captain Liu, would you like to answer any of those questions? There's a specific question directed on you on your position on ramming water cannons and use of lasers in the South China Sea.
Yes, and first I would like to clarify that the Chinese government would not accept to use the gray zone operation to define the Chinese operational law enforcement operation, because in the Chinese perspective and the law enforcement operation and the military operations, that's very clear. There's no green zone operation. And when we talk about the armed force and used by the Coast Guard vessels to counter in the maritime incident until right now, and I think it's very clear how to then make a definition of the armed forces. And in the wartime, and the armed forces and only gun and cannon and something like that. And in the peacetime, and if we treat it as a principle of the armed police, or the police and use the armed forces, the principle, just first is a very important principle is proportional. So if we talk about something like water cannons or just ship gliding, I don't think then is something like that used in the armed forces. And just like the 1988, the Black Sea collision that happened between the U.S. and the USSR, and we don't think that these two nuclear power and treated this collision as armed forces and uses. And yeah, that's my.
Thank you, Captain Liu. Dr. Permal, would you like to answer any of those questions on the ASEAN outlook on Indo-Pacific law enforcement agencies in the South China Sea, gray zone tactics, and UNCLOS maritime zones and Gulf of Tonkin agreement, 9-line, FORSHA, any of those questions?
Judge Caprio have attended to the gray zone tactics, so maybe I'll address the ASEAN outlook on Indo-Pacific. Yes, ASEAN have adopted the outlook on Indo-Pacific, and I think many Indo-Pacific partners are working together with different ASEAN Southeast Asian countries to implement the outlook, capacity building, governance, maritime governance, and also helping coastal state to understand the UNCLOS, international law, and also to train them in various form of capacity. So I believe that ASEAN outlook on Indo-Pacific is actively being done in Southeast Asia. On Malaysia's chairmanship of 2025, ASEAN chairmanship 2025, the focus of Malaysia's, as stated by the Prime Minister, it has to do a lot more with economic integration among Southeast Asian countries, and also to achieve ASEAN political security community in 2025. So the focus will be there, and this again will not focus on conflict-based issues, but Malaysia cannot. Yeah, Malaysia will also address other security issues such as the Myanmar problem and also the South China Sea. For the information of the members, MIMA, Maritime Ministry of Malaysia, together with the Ministry of Foreign Affairs, will be hosting our South China Sea Conference, Malaysia South China Sea Conference, with the support of Indo-Pacific partners in December 18 to 19, and many of the issues, military development, legal development, and also the role of ASEAN in reinforcing a peaceful South China Sea will be addressed during the conference. So this is one of the capacity building or cooperation that Malaysia has with the Indo-Pacific partner vis-à-vis the South China Sea. Thank you.
Thank you, Dr. Permal. Dr. Vu, your brief answer, please, because after your answer, we will conclude this panel because the next panel would need to start.
Thank you, Madam Chair. I would like to answer to the question posed by Professor Furuoka from Japan. In order to counter gray zone tactics, I think we need to listen to a great leader from China. Mr. Deng Xiaoping, and he said, black cat, white cat, it doesn't matter as long as it catches the mouse. So in order to deal with gray zone tactics, we can use all kind of measures that we have, either it's Navy, Coast Guard, or maritime militia, as long as we act in accordance with international law to counter these tactics, and it will be fine. Thank you.
Thank you so much, Dr. Wu, and to all members of our panel. Thank you so much for your presentations and for your answers. Let's give them a round of applause.
There you have it, ladies and gentlemen. We just concluded the second panel, and we would like to request our panel, together with our panel chair, to please rise for a quick photo opportunity before we proceed with our break. I'd like to request our cameramen to please be ready, and for our background to be changed to a little bit lighter tone. Thank you. All right, look at the camera in 3, 2, 1, smile. Thank you very much, ma'ams and sirs. Right now, we'd like to announce a quick 5-minute bladder break. We can also get our snacks inside, as we will be starting our next panel at exactly 3:45 in the afternoon. Just a quick break where we can get our snacks, and we'll proceed accordingly. Thank you very much.